Hello everyone. Thank you for tuning in to another one of my videos. My name is Cliff and I'm here making a bunch of videos and material relating to our Lord and Savior Jesus Christ. I'm doing this material in regards to the things that are going on in this world. The video that you're about to, or the material that you're about to see relates to the confusion with law. Everybody doesn't know that we are all, each and every one of us, are sovereign. And the system has fooled us into making us believe that we belong to another state or another institution, another being. Each and every one of us are separate, and we only have one owner, that is God, our Creator. And we are supposed to live under that thought, that realm, and that being. The confusion that the world has allowed us to put ourselves into has simply tainted our blood. I'm going to give you this material so you can get a grasp of understanding that you are not the straw man. The beginning of confusion.
Show me the law. I'm going to show you the law. I found it. They've been hunting all over for it, and I found it, and so we're going to get into that. However, this seminar is divided into three parts. The first part is the foundation. You will not be able to understand. You'll be looking right at the law and not know you're looking at it if you don't have the foundation. You've got to have this foundation first. So we're going to spend the first 7 hours on the foundation. It'll only take about an hour to discuss the law itself, and then it will take another couple of hours to show the remedy on the law. And the law and the remedy on the law, I think, will be quite apparent if you have a good foundation. So pay attention to that foundation. That is really, really important. It took me many years to focus in on it. Took a lot of bad decisions. You know, we got a lot of experience here. Where did that experience come from? It came from bad decisions. Okay? Experience comes from bad decisions. So we've made our bad decisions along the way. We got the experience. Now we can make good decisions based on that experience. So this is the foundation. What you see here, by the way, is on the website, 1215.org. Okay? This is the Nitty-Gritty Law Library and Sovereign's Paradise putting on the show here. And this foundation, if you get this foundation down pat, you pretty well got it knocked. You can pretty well handle any situation that comes along. However, handling any situation coming along does not mean you have a license to harm other people. This is all premised on you being legally right, lawfully right, and morally right. If you don't have all three of those factors down, then you've got a problem. And if you are, it's possible to be legally wrong. You can be morally right and lawfully right, which means common law right, but you could be statutorily wrong. Well, the statutory wrong, that has to yield to the common law. Okay, so if there's a conflict between the common law and the statutory law, the statutory law must yield. Now you see, if you look at the codes say particularly in California, I think it's the either the Civil Code or the Code of Civil Procedure, I forget which. But I think it's 22.2, which says basically that that the common law shall be the rule of decision unless, or so long as it's not in conflict with the statutory law. And that is true if you're in the statutory house. If you set up your case to operate under statutory law, then that's how it's going to be. But in truth, the common law takes precedence if you start off in the common law house and use it. But we'll get into that. Anyway, the first thing I want to cover is attitude. This is really, really important. If you have a bad attitude, if you have an attitude where you're always angry, you're always upset, well, obviously, court procedures won't be fun. And let me tell you something. Court procedure can be lots of fun, especially if you're in charge. And but you have to have a good attitude. If you have an angry attitude, this will work against you for a number of reasons. For one thing, people start off simply not giving you the credibility. For some reason, anger reduces the credibility, the perception of credibility on the part of other people. So you basically have to be a very calm, very friendly kind of person, regardless of the issues that are going. So you, plus, if you are a person who is emotionally locked up and you're into anger, or if you're in any strong emotional position, be it happy or angry, you will be blinded to your opportunities. You will not see the opportunities that are there because of how your mindset will color your ability to perceive. So your mindset very much controls your ability to perceive. So the proper mindset, if you really want to do law well, is you've got to neutralize yourself and be open to everything. Don't be automatically rejecting things just because they conflict with whatever you're seeing or thinking or whatever. And by the way, this rule that I'm giving you applies to attorneys too. And the beautiful part is every attorney that I've ever had to deal with had a mindset that I was absolutely ignorant because I'd never been to law school and didn't know anything. And they took liberties, and they weren't sensitive to the stuff I put into the papers, and then wham, they get it in the end, you know. And the very common thing that I hear when I go to court is the attorney says to the judge, he says, "Your Honor, I don't understand his paperwork." Well, the judge understands because he went through corrective schooling, commonly known as judges' seminars. You know, they have programs where they teach judges what the real law is because somebody's got to keep the system straight, and they do. In fact, I've noticed a remarkable consistency in the codes. And I know the attorneys aren't that smart. And I've wondered for a long time, how is it that they passed all these laws and had it right? Well, you look at the legislative procedure, and what they do is they pass it through to the legislative committee. And so one time I went up to the Capitol in Sacramento, and I thought, boy, this is an opportunity. And I went to the legislative committee's offices, and I happened to get a hold of a supervisor. And so I was all primed to ask the supervisor about the process they went through and how they reviewed it and so forth, you know. It took about 30 seconds for me to realize this person didn't have the first clue of what the real system was. So I had to change my program. And what I did was I asked the person, I said, well, could you explain the procedure, just exactly what happens when a proposed statute comes to your office? What is the next step? And she says, oh, well, what we do is we have a meeting with the judges from the Supreme Court, and they critique it for us as well. And we work it out in a committee, in a meeting. So there you are. Here I thought that the fountain of knowledge would be in these legislative committees. Turned out they didn't have a clue. The real fountain of knowledge is with these high-level judges. They know. I've never had a problem with a high-level judge. I may have had problems, but they were all legitimate problems. they understand, they're well educated, they're intelligent. These guys know. And if you get your act right, you'll get the results. So, again, its attitude is very important. When they perceive you as basically a good guy, that's what counts. There was a very important lesson came to me out of that, and that is, make sure you're likable. I'm friendly to the judge. I'm friendly to the attorneys. You know, I have to admit, one of my moments of glory was when I had an attorney screaming at me so loud that you could hear the echoes off the end of the hall that was 300 feet away. But that was a rare opportunity. That doesn't happen every day. But even that guy liked me as a person. You know, he was just angry because he wasn't getting what he thought he should get out of the courts. But it's very important to have the right attitude. Get the clerks to like you. Those, you know, people don't have an axe to grind against you when you first walk in. But if you show an attitude that's bad, you can generate dislike, you can generate lack of cooperation. And I can tell you that some of the best research we've ever had done was done by the clerks themselves to help us. It's just amazing because they really like this. They perceived us as good people. I go in, I talk to the clerks all the time, and I do talk to them, you know, on a personal basis. And hi, how are you? How's the family, kind of thing. And you tell them a joke or something. So, and it's a good way because then they start cooperating with you. You don't look so much like a kook. Remember, you're doing some very, very strange things. At least they look strange to these people, even though we have hundreds of years of tradition behind us. It looks strange to them because they're simply not taught. The attorneys are simply not taught this stuff. They have no clue. And coming from you, well, you have no authority as far as they're concerned. You know, what do you know? But you know a lot if you follow these procedures. So I'm just emphasizing this attitude is a big, big factor, much bigger than we really anticipate. And we get a lot of behind-the-scenes help from people that we could never prove we were helped. But I've seen judges do 180-degree turnarounds mysteriously. Just there were tigers on the bench, and suddenly they became like kittens. They were very nice and cooperative and so forth. Part of that was because of the fact that we fenced them in with the real law. But a big part of it also was the fact that they liked us. In one case, I remember this judge just absolutely raking the attorney over the coals. It was spontaneous. You know, we weren't expecting it. We didn't even have any motion that was even close to it. But this judge went into a tirade against the attorney and told the attorney, you know, that the attorney was the one that was responsible for the delays in this case, and the attorney wasn't doing her homework, and the attorney wasn't doing her research. And I mean, he just went on and on for about 5 minutes on this attorney. And this was an attorney who had 5 years of experience in the court system. But I mean, when we went into that courtroom, we always said, "Hi, Your Honor," and "Nice to see you," and so forth, you know, and then we got down to business, of course. But on a personal level, it was just fine. And I know that these people will stab you in the back first chance they get, you know. But when they like you, it takes a big chunk of energy out of their sails there. Yeah, wind out of their sails. So this is attitude is not law directly, but boy, it sure can have some surprisingly good effects if you have a good attitude. Okay, well, enough of attitude. Now we have language and dictionaries. Now, language and dictionaries, basically in America, we all speak 3 languages. The low-level language is called slang. Okay, that's the language of the street. It changes from moment to moment, from block to block, okay? So, and slang has some very interesting features in it, you know. So the formal English is our second language, and in order for strangers to communicate, we have to be educated in formal English or business English, if you want to call it that. And so that's an important language too. But it is a separate language. Even though it's also called English, it's a language that's separate from the slang version. And then there's the language of the court, sometimes called the King's English or legal English. And that's a very, very stable language. That, you know, a word means the same thing today that it meant 300 years ago. And precedence is very important. And the legal dictionary is far larger than Webster's unabridged dictionary. The legal dictionary, if you go to the law library, the legal dictionary is not called a dictionary. It's actually called words and phrases, okay? Or you'll see that it's the restatement of the law. That's another name for it. Or American jurisprudence. These are all dictionaries, as far as we're concerned, dictionaries of the English language. And if I remember the word "to," spelled T-O. I remember it took several pages of court cases where battles were fought over the meaning of the word "to." It really surprised me when I first saw that. So be sure when you are using the language, be sure that you're speaking the right language and you know that language. When you one exercise that you could do that I did is just sit down with the Constitution and one of these dictionaries, and every single word, just pretend you never saw the language before, and every single word, no matter how simple it is, you know, what it starts off, we, W-E, look it up. You'd be surprised what that word means when you're talking legal language. And so if you did that, that would give you a tremendous force, you know, intellectual force behind you to make you more effective in writing your papers. It also makes you more effective in undermining the opposition, because often these attorneys, you see, when the attorneys go to law school, sure, they're taught a few meanings and so forth, but they're not actually told that it's a separate language. They don't realize that. And they will go in there, a lot of times you'll hear attorneys on the floor of the court speaking business English. You know, you can just chop them up with if you pretend that they were speaking legal English, you can really screw them up, okay? Because they don't know, they're not educated. Attorneys are remarkably ignorant. I don't mean to downgrade attorneys, because I'm not saying they're dumb. They're very intelligent. A lot of them are extremely intelligent, okay? But being intelligent isn't good enough. You also have to use the right words. If you don't speak the right language, you can get in trouble in the courtroom. I think a very common misuse of word is the word resident, okay? You know, you ask anybody on the street what the word resident means, and resident means, well, you know, you live there, you belong here, right? That's your normal meaning for the word resident in everyday English. But when you get into the courtroom, the word resident means you're a foreigner, and you're here for a specific purpose, and once you accomplish that purpose, you're going to go home. If you're a resident of California, that means you're from someplace outside California, and you've got some purpose, and they assume it's a commercial purpose. Why do they assume it's a commercial purpose? Very simple. The Constitution of the United States authorizes Congress to regulate interstate commerce. And so if you say you're a resident of California, that means you're from outside the state, you've crossed the border, you've got a commercial purpose, and therefore they're entitled to regulate you. And that's by authority of the people who gave them the Constitution. So, very important to understand that word resident. Now, if you don't want to be a resident under those terms, the proper word is domiciled. Okay? If you're domiciled, that means you belong here. You don't need any excuse. This is where you live, this is where you belong. But if you're a resident, I'll show you an example of a common use of the word resident that is proper, that does match up with the legal meaning. And that is where a doctor does his residency in the hospital. Right? He went to school, he got his MD, but he's not allowed to practice medicine, not till he completes his residency. So he goes into the jurisdiction of the hospital, crosses the border. He's now subjects himself to their instructions and command. He goes through all the hoops that they have him jump through. And then once he completes the program successfully, he leaves. He leaves the hospital and goes out into private practice. And he has completed his residency. So there's a really good example of what residence means. So anyway, make sure you get your language right when you write your papers, and please, please pay attention to your spell checker, okay, on your word processor. If you put in paperwork with misspellings, I mean, some of the stuff I see is pretty sad. And believe me, when you put in bad spelling, the opposition looks at it and they figure one way or another they're going to beat you. You're too ignorant. Okay? So you can't do that. If you have trouble spelling, for Pete's sake, go down to one of the secretarial services and hire a secretary to read your paperwork and correct the spelling and correct the language. You know, sometimes we use slang without realizing it. So a good executive secretary can do a lot to save your paperwork from being disrespected. Okay. All right, let's get into the meat of this. People or citizen, which one are you? Basically, the people own the country, and the country owns the citizens. That's the basic relationship. So which do you want to be? You want to be a people, or do you want to be a citizen? You cannot be both at the same time. However, if you're one of the people, you can choose when you want to be a citizen. You can be a citizen for some purposes and not a citizen for other purposes. Now, how do you know whether or not you're a people? Well, if you look at the preamble, well, let's back up. Let's go into the history. When the United States declared its independence from Great Britain, King George wasn't too happy about it, and he got a little bit vindictive about it, and so he retaliated by canceling the charters that were granted, giving the governmental age, or giving the colonies official recognition. He canceled those charters. So the result is that, technically speaking, there was no sovereignty, no sovereign law. So everybody became self-governing. We governed ourselves. So everyone became sovereign. And so when we finally got together for this modern constitution, I know we went through a phase. The colonies put together the Articles of Confederation, but that was the business of the colonies, not the business of the people. So when that wasn't working out, the people themselves stepped back into the picture. I mean, this is all theory, but it's theory that we generally accept in legal circles. And so the people stepped back into the picture, took command of the situation, and redefined the system. And so, and this is expressed in the preamble. If you look at the preamble, it says in the preamble, "We the people of the United States." Okay? So that we the people stepped in. Now, what we did, we had a purpose. We said in order to form we said where we're from. We're people, we're from the United States, and our purpose was to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity. And what are we doing? We ordain and establish this Constitution for whom? For the United States of America. So we the people were from the United States, which is two words, and we ordain and establish this Constitution for those guys over there called, four words, United States of America. So, you see, we were basically the creators of the United States of America. And the word ordain means to authorize, to make law. So this is the law of the people speaking. And we, by ordaining, we created this whole thing in the legal sense. And then we established this Constitution. And the word establish in this sense means we actually put it on paper. We wrote it. Okay? So we the people authorized it, and we the people established it, wrote it. so that there wouldn't be any confusion, I presume. So I want you to notice those words, ordain and establish. The people were sovereign, self-governing to begin with, and there is nothing in the word ordain and establish that says that we gave up anything. We were sovereign before we created it, and we're sovereign after we created it. So we, the people, gave up nothing. Well, that was a tough thing for the politicians to swallow. Okay? And over time, that was not really compatible with what they like to do. And because governments like to grow, and unfortunately they don't know when to stop, so they grow to the point where they consume their own people. But this Constitution was written in such a way there was no authority on the part of the government to do anything with the people. The government was a separate entity with its general functions, but there was nothing in the Constitution that authorized the government to take control of the people. So they had to do something about that. It took a long time for them to figure out what to do. But eventually they figured it out. They came up with this device called the 14th Amendment. Now, if you look at the 14th Amendment, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. You see, you're not a citizen of the United States unless you meet two basic conditions. The first condition is you have to be born here or naturalized, one of those two, but that's the first condition. The second mandatory condition is that you have to be subject to the jurisdiction. Well, if you're born here but not subject to the jurisdiction, then you're not a citizen of the United States. What are you then? Well, you're one of the people. The people are born here, but they're not subject. It's quite the opposite. The government is subject to the people. Okay? We, the people, ordained and created, or ordained and established this Constitution for those guys over there. Those, and by the way, they're not really the government. The true government is the people themselves. We are self-governing. The proper terminology, although we call the United States of America organization a government, it's actually a government agency. Okay? You notice they're all called agencies? That's because there are agents. They're the agents of the people. They're carrying out tasks that we have mandated that they do for us if they want to get a paycheck from us. Okay? So, when you're a citizen of the United States, you become property of the United States. You have no rights, by the way, as a citizen. All you have is privileges granted by the government. But anyway, that's the background on that. Okay? So, if you're going to be one of the people, you have to know the difference between that and being one of the citizens. Now, you can be a citizen for some purposes and not a citizen for other purposes. After all, if you're in your sovereign capacity, you have the power, the legal power, to decide when you will or will not go into a contract with another party. And the federal government and the state governments are nothing more than other parties, okay? So, and this is how they get you. You know, you sign the 1040, there's your contract, okay? There's a number of things you contract, but these contracts do not grant general jurisdiction over you. They only grant jurisdiction over you for the purpose of that particular contract. If you have a driver's license, that does not mean you have to pay taxes. It does not mean you have to do a number of things. It only means that you have to have the driver's license according to your contract with them when you're doing the activities covered by that license. By the way, does anybody have a driver's license here? Okay. Pull it out and look at the back of it and see what it says. You might be surprised. It's in tiny print. And a lot of people cannot read small print. Okay? What does it say? Somebody read it out loud. This license is only valid for driving a motor vehicle. You ever wondered what a motor vehicle? Now we're going to talk legal language here. You know what a motor vehicle is? A motor vehicle is a self-propelled contrivance used in commerce. What does used in commerce mean? It means carrying passengers or cargo for hire.
18 U.S.C. 31.
Right. If you look under, first of all, if you look at under California Code section, I think it's 15210, that's the one that says that the California definitions shall apply unless there's a federal definition. Okay? So California is not being subjected to federal jurisdiction. It's the other way around. California is volunteering into federal jurisdiction. So that's not an issue about whether or not there's federal jurisdiction. It says specifically in the code that, yes, they are obligated, you're not, but they are obligated to obey the statutes. And you don't need that dictionary because we have it specified in the statute exactly what a motor vehicle is. And it's got to be a self-propelled contrivance used to carry passengers or cargo for hire. And if it's not doing that, it's not a motor vehicle. It's that simple. You don't need the dictionary. If you look at the definition in section 15210, the state has volunteered into federal jurisdiction as far as definitions go. And by the way, all the states that receive federal highway funding, they have to meet federal standards. And so one of the federal standards is Title 18, Section 31, which has definitions. And in there you will find motor vehicle, 2 words, specifically defined as a self-propelled contrivance that's used in commerce. And then if you look further down in Section 31, you will find where the phrase used in commerce is specifically defined as carrying passengers or cargo for hire, or something close to that anyway. So if you're not engaged in some form of, if you're not driving a motor vehicle, then you don't have a license to do what you're doing if you're just traveling. And then you don't need one. Where's the jurisdiction? So the cop out there on the street, he doesn't know he doesn't have jurisdiction, but he doesn't. Not if you're not engaged in commerce. Now every trucker out there who has a driver's license who is carrying passengers or cargo for hire, yeah, he's subject to the rules. Okay? And that's constitutionally authorized by the people. So just have a clear understanding whether or not you're using this vehicle in commerce. It's not good enough to be a vehicle. It has to be a motor vehicle to be in the jurisdiction. Okay, so yes, sir.
When you get a driver's license, then you're asking for a license to do that. Are you now not alleging that you are?
No, the license is only for the license is only for that activity. Okay, there's nothing in the licensing process that says that now you have to have it for travel. It's all commerce. I don't know if you've noticed it, but the motor vehicle department is under the tax collection department, and I got some very, very good advice one time from this fella. His name was Abraham Lincoln. Okay, I know a lot of people have some opinions about him, but he was an attorney. Okay, and he brought out a very important point, which is if you don't want to argue a point, don't bring it up. Okay, don't put in your papers that I reject the birth certificate. Just don't even mention it, even if you have one. Okay? If they bring it up, well, sure, you attack them on it. But, hey, you know, there's just too much. If you tried to cover everything, your papers will become like encyclopedias, whether you're one of the people or one of the citizens. So if you're one of the people, you own the government. If you're one of the citizens, you are subject to the government. You're subject to the whim of the government. So you don't have any rights when you're a citizen. Why? Because you're subject. You know, you must conform to whatever the rules are that they've laid out for you citizens. So a citizen does not have a right to own a gun. Okay? I know that's a big issue with a lot of people, but a citizen simply does not have a right to own a gun. He has a privilege to own a gun. It's a legislated thing. Okay? And there may be legislation somewhere that says if we haven't legislated it, it's okay for him to do it. Okay? But basically, it has the privileges. Citizens live by privilege granted by the government. And by the way, they don't like to call them privileges. That might wake the citizens up and get them to thinking about being people. But so they give these privileges a special name. They're called civil rights. Okay? Civil rights are actually civil privileges granted by the government. What, if you want real rights, they're called natural rights that you're born with when you're one of the people. Yes, sir. Citizens, if you look at the 14th Amendment, it very clearly, very simple words, it says to be a citizen, you have to be born or naturalized and subject. If you're not subject, then you're not a citizen.
Hang on, but okay, I just understood you. In other words, there's no law that requires the people to file, but there is a law that requires a citizen to file because it's a privilege.
Right. You'll see that when the statutes are written, they refer to persons, not to people. The word people is not the plural of person. The plural of person, singular person, is persons with an S. Anybody remember the O.J. Simpson trial? You remember the Fourth Amendment issue, the exigency that was being considered in the municipal court before they transferred it to the Superior Court? That judge, she was, I don't think she was smart enough to write that opinion. I think somebody helped her on it. But when she read the decision, which essentially a lot of people said suspended the Fourth Amendment, when she read that decision, she was absolutely on target. She never used the word people anywhere in that decision. She referred to person or persons all the way through, from beginning to end. She had her language right, and when you understand that citizens live by privilege, not by right, she was right on target with that decision. There were a lot of attorneys criticizing her, and those attorneys were wrong. Now, if O.J. Simpson's attorneys had the understanding to take the position that he was one of the people, that might have had a different outcome.
I have a question.
Yes, sir.
In terms of the 14th Amendment, so would it be correct to say that as a person who is domiciled in California, born and raised in California, that I am one of the people of California and a non-resident foreign to the United States government? Is that
You do not have to accept U.S. citizenship. You know, you can just be a resident. Remember, the true country is California, and the United States of America is merely a corporate trust. I mean, if you look at the preamble, it has every element that you would expect to find in a trust. It has the trustor, the trustee, the beneficiary. It has the purpose. Everything's in that little short paragraph, all the elements. And so and you can tell that the United States of America is actually a corporation. Mm-hmm. The way you can tell is very simple. It has a president. All corporations have presidents. Countries have governors. Because they have a governor because he's acting in behalf of their people, their boss, which is the people. Okay. You're welcome. So anyway, what we're going to talk about here is the Bill of Rights. Now, if you're one of the people, you've got all rights. Okay? I mean, when you delegated authority to the United States of America or to the states, you delegated that authority. You gave up nothing. You're still sovereign. Okay? So we'll get into sovereignty in a little bit, what sovereignty is all about. But I want you to know that if you're one of the people, you have all rights. Whereas if you are a citizen, you only have certain rights. No. I'm an American. And I'm talking about citizens and people. And this is part of the entertainment. You don't want a boring session on law, do you? Come on, we got to have a little sense of humor here.
Well, you know, sometimes Aurora is a little girl, don't understand. I have to ask.
No, it's attitude. You know, you got this whole legal process should be fun. Okay, you got if you're steeped in anger and all serious, I'm sorry, but you're shortchanging yourself. Yeah, you got to talk right into it.
Okay, the 14th Amendment has not been ratified, so how can we have the 14th Amendment?
Okay, the 14th Amendment has not been ratified. I don't think I have the microphone on here. I think we need the microphone. How's that?
And also the 16th.
Okay, the issue that has been brought up is that the 14th Amendment has never been ratified. Let me tell you something. That's not important. Okay? We're dealing with, let's put it this way. When you go to China, if you were in a Chinese court, do you think you would argue your case in English? Or would you argue your case in Chinese? Yeah, you want these people to understand you. Now look, I go into a courtroom and I know the attorneys, the clerks, the public that's out there watching what's going on, they all believe that the 14th Amendment is valid. And maybe even the judge, he may believe that it's valid. Okay? He may be poorly educated as a judge. So I play the game. And I'm going to play the rules as much as possible according to their understanding, so long as it doesn't give up my rights. Now, if it gives up my rights, I'm going to educate them. All right? But as long as their rules help me, I'm going to use their rules. I'll apply them. And so they think the 14th Amendment is valid, so do I. Okay? And I'll use their own words against them. So the 14th Amendment says that you have to be born or naturalized and subject. Well, I'm not subject. That's what they believe in, and they believe in that word subject. And I'm telling them, I'm not subject. I'm over here, over on the preamble. Okay? So, again, if you don't want to argue a point, don't bring it up. You can develop a whole case on whether or not the 14th Amendment is valid. For what? You know? Doesn't apply to me anyway. Well, I'll let them have it valid. Sure, it's fine. It's valid. Okay? Doesn't apply to me because I'm over there as a people. And I choose not to volunteer into citizenship. Not for that purpose. You can be a citizen for some purposes and not a citizen for other purposes. You're subject to the jurisdiction. So I guess that's an adverb, isn't it? Well, if you subject yourself to the jurisdiction, then you're granting them the authority. You're the source. The requirements for citizenship are that you have to be born or naturalized and subject to the jurisdiction. If you're not subject to the jurisdiction, then you're not a citizen. And so, and it's your choice. This is a free will choice that you can make. And of course, they snooker you into making the choice they want you to make by simply regulating the education that they give you when you're in the public schools. Okay? They don't teach you the words of freedom. They teach you the words that subject you, that put you into their jurisdiction. So they don't teach you, all you ever hear when you're in the school area is you hear about being a good citizen. You hear about being a resident. You hear the word resident used all over the place. How often do you hear the word domiciled? Okay? But the word domicile is the one that gives you the freedom. All right? Then you have another interesting thing is that you'll notice that in all the public schools, you have to register. Your children are registered into the school. Instead of, they used to say enrolled. Now they say registered. What's the difference? Well, registration, excuse me, registration is when you register something that came from the outside the jurisdiction. Enrollment, you already belong in the jurisdiction. We're just putting you on the list. But registration is when you're outside. You ever heard of a ship's registry? Well, the ship is registered outside the jurisdiction. Okay? Ships go into other jurisdictions, so they have to register. So, when you enroll, you're from here, the jurisdiction that you're enrolling in. That's why they say registration in school now instead of enrollment. And of course, the people are not well educated, so they sometimes mix these words. I didn't say that. I said it the other way around. If you are subject to the jurisdiction and if you are born here, then you are a citizen. Was he part of the prosecution?
Yeah.
Okay, you prosecutor asked her. You want to know if she was a citizen. You'll notice that on the criminal papers, the charges or whatever it is that they generate in the district attorney's office, you'll see that they'll put your social security number and your driver's license number on there. Okay? Why? Well, that's proof you're a citizen. Okay? Prima facie proof, by the way, which means that you can upset that assumption. They'll make the assumption until you counter it. Okay? With your counterclaim. Okay? We'll get to that. That's part 3. Okay. So I just want you to be aware of the difference between people's rights and citizens' rights. Now, I went to a book. This book is published by the Senate of the United States. The Senate gives a free copy of this book to every senator, every congressman, and to the vice president. Why doesn't the president get one?
The executive branch.
Yeah. The president's in the executive branch. The vice president is part of the Senate. He's the president of the Senate. And so he gets a copy. Now, this book is called The Constitution of the United States of America, Analysis and Interpretation. Okay? And that's a very interesting book. It's got some 3,000 pages almost. And if you go to the book, which is called Senate Document 99-16, on page 956 and 957, footnote 12, you will see a list of the privileges that are available to citizens. Okay? So, for example, the First Amendment of the Bill of Rights is available: religion, speech, press, assembly, and petition. The Second Amendment is not available to U.S. citizens. Quartering of troops, there's no cases, but they decided to throw it over on that side anyway. Okay? Grand jury indictment, you're not entitled to a grand jury indictment. You're not entitled to a jury trial in civil cases if you are a citizen of the United States. And you're not entitled to bail necessarily. And you're not entitled to protection against excessive fines or equal protection. Okay? All of those are not available to the U.S. citizens. That's the Second, Third, Fifth, Seventh, and Eighth Amendments, the Bill of Rights. On the other hand, they have legislated that you are entitled to the First Amendment, Fourth Amendment protections, Fifth Amendment, double jeopardy, self-incrimination, and just compensation, and the Sixth Amendment protection has been so much diluted, but the Sixth Amendment, you are still legislatively entitled to speedy trial, public trial, jury trial, impartial jury, notice of charges, compulsory process to get witnesses in, and a right to counsel. And you are entitled to protection against cruel and unusual punishment. So that's the list right there. It's right in the Senate book. Okay? I love that book. It tells the truth. Now, it isn't that they don't want it. It isn't that they don't want to lie. Yes. Well, every once in a while, they publish this book. Okay? I think the first one was published back around 1910 or something like that. And it comes out every so often. There's been as few as I think 3 years between publishings, and there's been as many as 25 years between publishings. But every once in a while they come out with a revised edition. and it basically brings in new court cases that have affected and so forth. It's a very good book, actually. And but if you lay down, and I've done this, I've taken a very old copy with a very new copy, and I put them side by side, and you can see that the language that they use, they don't change the concepts, but what they do change is the wording to describe the concepts, and the newer books make it easier to misinterpret. The older books were clearer, were more clear, okay? And, yeah, obfuscation. And you'll also notice that in the old books, if you look in the index, there's almost a full page of references to the common law. And in the newer books, there's 0 reference to the common law. It's still in there, by the way, the common law. If you know where to find it, it's still there. Now, the beauty of it is this, is that this book I've got on the website, okay, and you can search it, okay? There is a search engine on the website, so you can look up stuff, and it will lead you to that book. Okay, so that's kind of neat.
Bill, how often is that book updated?
Well, like I said, I just said 3 years one time, another time is 25 years went by. You know, it depends on what the urgency is. Now let's get into sovereignty. Okay? It's very important to be sovereign. Okay? If you're not sovereign and you decide to be a citizen, this is how you might end up. Okay? So, I don't think you want to be like this. So, I suggest you be sovereign. It's a lot more fun, a lot more... Okay? But anyway, we're going to talk about sovereignty. And so, we were self-governing 100%. And then the colonies got together and decided to form an organization themselves, and so that was the Confederation. You had the Articles of a Confederation to set the rules. Well, that didn't really work out as well as I guess some people wanted. So we had our Constitutional Convention and revised it considerably and came up with the Constitution. So in the Constitution, if you read the last part of the Constitution, you'll find that the people had decided to use this Constitution, but it would only be put into effect if 9 of the colonies would agree. I guess they were states by then. And so when they got the 9 to agree, then it was a go. If they couldn't get it, it would have been a no-go. So the states were contracted into this whole thing, okay? The people ordained it, but the states contracted into it. Okay? This is why the states cannot back out, is because they have a contract that was not allowed to be broken. Okay? Now, there's some strong argument about the southern states wanted to break out because the northern states were not playing according to the rules. And the southern states wanted to hold closer to the Constitution, and the northern states, who were primarily manufacturing, were more into the Admiralty style of operating. So that created quite a difference of opinion. I've seen the actual letter or order that was signed by President Lincoln authorizing the invasion of or the declaration basically of war on the southern states. And the actual reason was failure to pay the taxes.
By the Southerners.
The southern states, you see, the federal government got its funding from the states. And so they failed to pay their taxes, so therefore it had to be enforced. That was the legal reason. The public reason, of course, was slavery. They had to round up the support of people, but the legal reason was that. So anyway, what do we got here? Okay, so interesting thing about sovereignty is I've pointed out to you by looking at the Constitution looking at the preamble, you can see the relationship. We ordain and establish it. So right there, that shows our relationship. And there's nothing that in there that says we gave it up. But California gets very specific. In California, if you look at Section 11120 of the Government Code, and that's the Bagley-Keene Act, or if you look at Section 54950 of the California Government Code, which is known as the Ralph M. Brown Act, both of them have identical wording. And if you look here in the Bagley-Keene Act, it says right there in the third paragraph, the people of this state do not yield their sovereignty to the agencies which serve them. That's a pretty clear statement to me. You look at the California Government Code, the Ralph M. Brown Act, and it says in the second paragraph, the people of this state do not yield their sovereignty to the agencies which serve them. Now, there is one interesting difference between the two statements, and that is that in the first one, state is lowercase, and the second one, state is capitalized.
Why is that?
Don't know, but it doesn't matter.
Okay.
I do not yield my sovereignty. Whatever interpretation they make does not apply to me. That's the beauty of this whole concept, is that a lot of these things that might be important when you're inside their system suddenly become meaningless when they're outside the system. Okay? So we're above the Constitution. We created the Constitution. The Constitution says right in the Constitution of the United States that we ordain and establish this Constitution for the United States of America. It wasn't for the people. It was for the United States of America. Okay? So that's why it doesn't apply to you or me. It applies to them. And it's more than... And one of the things that we have on here is an Army publication where the military used to have educational material teaching people, certainly teaching their officers, what the difference was between a democracy and a republic. So, for some reason, oh, here it is. So you click on it. So this, yeah, they go into what citizenship is, and they point out that the citizenship always leads to a dictatorship or anarchy, but it does not lead to freedom. When you in a republic where you're sovereign, where you can suspend the rules on your own authority, so long as you do not impose on the sovereignty of someone else, well, that leads to freedom, because when the rules become obnoxious, you can just say, forget it, I'm not going to obey it. That's the beauty of a republic. And the founding fathers had a confidence in the public at large. They believed more in the people than they did in the specialists running government, because they knew how human nature is and how government nature is. So anyway, this is the publication by the military, very short. Training manual number 2000-25, and you just click on here, and we got a copy of it. It's on a it's in a word processor file. There it is. War Department, 1928. That was back when they believed in it. Yes. Okay, but anyhow, so they go into what citizenship is, and they go into all sorts of stuff, but as it relates to the military. But it's interesting, they no longer publish that manual, I understand, because basically they're trying to convert this over to a democracy. We go to the essay category on this CD. Under essays, I think this is where it is. We have, here we are. In 1792, Philip Freneau wrote an article in his newspaper on how to, he wrote the rules for changing a republic into a monarchy. And of course the intermediate step would be a democracy. So he lays out the whole plan, and if you take the time to read it, you'll see that's exactly what they've done. The one thing that's happening today that was never anticipated by the founding fathers was the arrival of the internet, electronic communications. Never in the history of the world that we know of have we ever had the high-speed communications. And I'm sure a few of you, certainly I do, have a mailing list of people you send out interesting things to, jokes or whatever, and for communicating. Well, that's the power of the press, personalized. You can duplicate your thoughts and send them out en masse for a fraction of a cent. That's pretty good. So it's an interesting, knowing my history as I do, which isn't all that great, but the little bit of history I do know, I think there's an interesting race going on between the government doing its natural thing, which is taking over its own people, versus the people becoming awake and doing something about it before it happens. And I'm not sure which side's going to win, but I'll say one thing: the internet certainly upset the formula. Anyhow, so there's that. Back to the foundation here. Okay, when California was admitted to the Union, it had to be a republic. So here's a copy of the admission. And they say, whereas the people of California presented a constitution and asked admission into the Union, which constitution was submitted to Congress by the President of the United States by message date February 13th, 1850, and which on due examination is found to be Republican in its form of government, being enacted by, and so forth, and they went and admitted the state into the Union. So all the states have to go through this process because the Constitution for the United States demands it, mandates it. They have to be a Republican form of government before they can join. Let's talk about a court. What is a court? There's a couple of definitions. One of the definitions is legal, and the other one's practical. Okay? So, on the practical side, all a court is basically the sovereign sitting on his throne surrounded by his courtiers, the people who gravitate to the center of power. So, the thing is that in the traditional perspective of what a king is or a dictator is, you have this story, this scenario. The king is sitting on his throne and he's looking out the window and he sees some knave out there stealing oranges off of his favorite orange tree. So he does the kingly thing. He sends the guard out, picks the guy up, throws him in the dungeon. Okay? That's all. Very simple. After all, he's the king. Well, what happens after that is on dungeon visiting day, the knave's brother visits him. And he complains to his brother about how unfairly he was treated. He really didn't, nobody heard his side of the story. And so it's unfair that he get 3 years of prison time, dungeon time, and so forth. And of course the brother, being a brother, is very sympathetic. And he says to him, yeah, that's a bad deal. He says, I'll take care of this for you. And that night, because the brother turned out to be the chief cook, the king dies of an overdose of arsenic. Yeah, that's all. That's how things got settled, sometimes. Well, that's a bad deal for kings. So we got this court system. Now, just let's recast the scenario. King's sitting on his throne. He looks out the window, and he sees some knave stealing oranges off his favorite orange tree. So far, the story is the same. So he sends the guard out. The guard goes out, picks up the guy, brings him before it. They accuse him of doing this. They ask him how he pleads. They get the various witnesses. They set up the procedure. They make an announcement, a public announcement. We're going to have this trial on a certain date. Everybody shows up at the trial, including the knave's brother, the chief cook. And they have the trial. They present the evidence. And then they have a decision, if necessary. Maybe have a jury out there, to look at it and so forth. Then they convict him, and then he gets his 3 years in the dungeon. Okay? Now, on dungeon visiting day, the brother visits the prisoner, and the prisoner complains about what an unfair deal it was, how he didn't really do it, and so on. And the brother says, "Look, bro," he says, "I attended your trial. I saw the evidence." I said, I'm sorry, but you kind of earned it. And so, as a consequence of that, the king gets to live another day, arsenic-free day. Okay? So what I'm pointing out here is that the number one purpose of a court, above all the other things that you've heard, all the things you've read about, all the court rules and procedures and everything else, the number one thing about a court is that it is a stage upon which the sovereign puts a show to convince the rest of the world that the sovereign is right. That's the purpose of a court. Okay? Nothing can violate that rule. I don't care what goes on in the courtroom and so forth. That is the number one rule you never violate. You must put on a good show. I've had people ask me questions about doing certain procedures and so forth, and then I ask them, well, is that a good show? Does that convince the rest of the world that you're right? Well, it turns out it doesn't a lot of times. Just because you're legally right doesn't mean you're right in the public perception. And who is this public I'm talking about? Well, it's the court clerk, it's the sheriff, it's the marshal, it's the cops, it's the mayor of the city if the case is important enough for him to notice it, and so on. It's all these people who hold the guns. Okay, you want those people to be convinced you're right. Now, they may know they're doing wrong and taking your rights away on purpose, but the first step is to have them know you're right. Now, when they know you're right and they're wrong, that takes a little bit of steam out of their efforts. Okay? There's something about us humans that in general we tend to limit ourselves. Just like I told you the story earlier about the Buddhist monk that was head of all the other monks. Nobody would kill him because they liked him. Okay? He knew how to run his court, so to speak. He knew how to keep things looking good so that as he did his damage, people held back. They didn't take retribution on him, even though he was a major problem internationally for the government. So that's the first consideration. A court is a stage upon which the sovereign conducts his show so as to satisfy the rest of the world that his decision is a good one. Now, sometimes you do find somebody not guilty, but basically you're the plaintiff, the sovereign plaintiff. You know what the person did to you. He knows what you did to you. I mean, between you know what the truth is. So why have the court? Well, it's because you're actually putting on a show for the rest of the world. So put on a good show, okay? Don't take shortcuts. It'll pay. So that's what a court really is, in practical terms. Now, there's all kinds of courts, okay? You know about admiralty courts, maritime courts, court of the exchequer, court of claims, all kinds of courts. But in America, there is only one court, and that's a court of record. All the other courts are what we call nisi prius courts. They are courts that exist because you failed to object. Okay?
And you called it what kind of court?
A nisi prius court. That translates from Latin into without prior objection. A nisi prius court is a court that exists because of no prior objection. Okay? So, and you'll see it's right here. You see it, I have it on the menu, nisi prius court. And one time, I got a letter from somebody objecting. And so I put his objection up on the website, and then I put my answer to it, describing a nisi prius court. It might be worth studying. But the important thing to understand about a nisi prius court is it's a court that exists without objection. So all those courts I mentioned are nisi prius courts. Another way, you could call them contract courts, but they're contracted because of your failure to object. See, you don't have to have an overt act to have a contract. I mean, an overt agreement. By the actions of the parties, you know there's a contract going on. You know, if I give you some money and then I walk off and take your car, we never had an agreement to do that, but you accepted the money and I accepted the car. You gave me the keys. Even if we never spoke a word, you know that there's some meeting of the minds there. Some agreement, right? After all, you took the money and I took the car. So a contract can exist on nothing more than the action of the parties. You don't have to have it in writing. You don't have to have the words spoken or anything else. Just what you did that shows there's a contract, an agreement, okay, or stamp a seal on it. And so the clerk stamped a seal on it. It was a rubber stamp, and it had 4 letters, S-E-A-L. Seal. That was their seal. That's the United States District Court. Okay? So that's all it takes for a seal. And so a seal's not exactly a big deal as far as its form, what its form is. However, a seal is an important item. A contract between two parties is always a quid pro quo situation. In other words, you get something for something. You give up something, but you get something in return. That's what all contracts are. Those are called bilateral contracts because they work both directions. A unilateral contract is not enforceable. Okay? If somebody says to you, "I'm going to give you $1,000 on Sunday," you don't have to do anything about it. I'm just going to give it to you. And you make plans on that $1,000, and when Sunday comes, he says, "I changed my mind." You have no case. Okay? Because there was nothing required of you. You didn't have to give up anything to get it. So a unilateral contract is simply not enforceable in any court. Okay? Now, having said that, there's one exception to that rule. And that's if the promise is sealed. If the person says, "I'll give you $1,000 next Sunday," puts it in writing and seals it, the seal is the consideration, and when that seal goes on it, it's real, and that is enforceable. So now they're trying to minimize the importance of the seal, and you'll see that a writing that is signed is considered as good as a writing that's sealed. Words to that effect. I don't remember the exact words that are in the statutes. But the thing that I notice is that all of government, all the courts, they all have seals. So I don't believe what I read. And it's a common law. They're not going to be able to change the common law. The seal is there to stay. Okay? Now, going beyond that, if you look in Black's Law Dictionary, you look up what a court of record is, you'll see in Black's Law Dictionary, the 5th edition, that a court of record has the power to fine or imprison for contempt. and that it keeps a record of the proceedings. Okay? So that's what Black's 5th edition says. It leaves out the other two requirements. If you look in Black's Law Dictionary, 4th edition and earlier, you'll find all 4 requirements there.
Interesting.
Yeah. The 4th requirement is that it's proceeding according to the common law. That means no statutes, no codes. Okay? A court of the highest court of the land is a court of record. Okay? No statutes, no codes. So, you're proceeding according to the common law. Anybody ever hear of statute of limitations? Doesn't apply in a court of record. Why? There's no statutes in the common law. If a court of record is proceeding according to the common law, then statutes don't mean anything.
So they make the bed, they better sleep on it.
Yep. Yes, sir.
Is there such a thing as an Article 3 court? Oh, yeah.
Well, yeah, but that's under the Constitution. We're outside the Constitution in the common law. We're in an Article 0 court. Okay? My own sovereign court.
So, I guess the first thing is you have to establish that you are proceeding under common law as opposed to statutory law.
Correct. Correct. And I'll show you how to do that. It's real easy. In fact, it's fun. When you see how we do this, you're going to love it. But we'll get to that. But anyway, ultimately, you challenge them. Because by what can we say that one human being has anything over another human being? Well, the response, the inquisitional response would be, well, God sent me to tell you. Now, how can you argue against God? Okay? I mean, that's the ultimate argument, at least back then. Well, if you look at verse 22, it turns out that we're equal to God. That means, if we're truly equal, now we're not equal in terms of creating life or creating universes and, a lot of areas, but we are equal when it comes to knowing good and evil. That's the point. And so you just simply say back to the person, well, thank you very much for bringing the message from God. I will take it under advisement. Okay? And you consider it. And if I get a message from God, I'm going to respectfully consider it. But I still have free will, independence, and equality to make a decision as to whether it's truly good or evil, whatever the issue is. And I don't know, might decide the pink shoes are okay if I were the accused, you see. So that's the beauty of that. Now, this is backed up by 1 Timothy, where the full name is Paul's First Epistle to Timothy. And Paul wrote a letter to Timothy explaining a few things. And one of the things that he explained was that, he says right in there, the law is for the lawless. Okay? It's not for the virtuous. There's 3 criteria that he names in there. You have to be faith unfeigned. You have to be, basically you have to have a good intent. And the law is not written for the person with good intent. The law is written for the person who is the lawbreaker. Now what we're talking about here is, you see, when Eve ate the fruit of the garden along with Adam, that was, according to that story, that is when we achieved the knowledge of good and evil. And that's sometimes called the law of the heart. In other words, you're born with this knowledge. Nobody has to teach it to you. You know certain things. And so, if you violate that law, then we have the written law to tell you what to do. Well, as it turned out, there were a lot of people, apparently, who ignored the law of the heart. And so, at some point in time, out came this thing called the 10 Commandments. And we told people what to do. You can't do this, you can't do that. Well, that law was not for the lawful person. That law, the Ten Commandments, was for the person who ignored his deal. And this reflects in our system of jurisprudence, because you know, for example, to pick a very obvious example, you know that one of the Ten Commandments is thou shalt not kill. Now you're driving down the street, you're doing 25 miles an hour in a 35 mile an hour zone, and a little kid runs out from between some parked cars and you can't stop and you kill him. Did you violate the commandment that says thou shalt not kill? No, in our system of thought, our philosophy, you are not held responsible. Why? Because you did not have the intent. Okay? If you have not the intent, then there is no conviction. You are not persecuted for accidents. Now that's different from what goes on in Islam. And I read about a case where this guy, an American, that might have had something to do with it, I don't know, but he parked in a parking lot, okay? And his car was the only car there. And he went into the building. While he was in the building, a hot rodder came around, happened to be a native, okay? And he went too fast to get around that curve, and instead of navigating the curve, he went off into the parking lot, hit the American's car, and I don't know if it killed him or not, but certainly it created major damage, okay? So it got into court, Islamic court. And the American was held responsible, and the judge explained it to him, that what had happened was that the American had made a choice. He could have parked somewhere else. But because he made the choice that he did, he was being held responsible for his choice. That's a little different way of looking at things, okay? So in our Judeo-Christian concepts, we do not hold you responsible for genuine accidents. We do hold you responsible when you intentionally do something. Or even if not intentional, if you are irresponsible. You know, if you're doing 100 miles an hour in a 25 mile an hour zone on a crowded street, that's probably considered irresponsible, you see. And that's why we have juries to draw that dividing line of responsibility. Anyway, so those are...
That was the Hammurabi Code, which is eye for an eye, tooth for a tooth.
Oh, Hammurabi Code, eye for eye, tooth for tooth. Okay. Well, yeah.
Islam.
Sure. Well, anyway, so that's my 2 cents worth on the religious or the biblical connection to our system. And I have been told that behind the scenes that these are effective rules. I don't know. I never speak about them in my actual papers.
Can you elaborate more on that international law?
Well, international law doesn't really exist. It's actually, they left a word out. It should be international common law. Because the international law operates just like the common law that we're familiar with. It's basically, you got to get together and have a contract to agree among yourselves and who's responsible for what. And they don't have a jury, but they assign a judge. But the judge, as things exist right now, has no more power than the participants agree to let him have power. The accused may decide not to go to the international court. So what do? Nothing, right? I mean, I think that's the status of things these days. So international court only works if the parties will contract to it. And that's basically how common law works, excepting that in the common law, if you have an injury, you can force the other person into the court. Why? Because we have a third party power to enforce it. Somebody with the guns that'll come in and back us up. That's called the marshal or the sheriff. Okay? We don't have that on the international level yet. At least it's not operating perfectly.
Well, the only thing that do your party is
Microphone.
war.
Yeah. Okay. So now, anyway, it's proceeding according to the common law and not statutes. That's what a court of record is. The fifth one is the killer requirement. This is the one that I just love. The tribunal is independent of the magistrate. Okay? Now, the tribunal is the one that does the judging. The magistrate is the one who's up there. He's not creating court orders, but he's enforcing them. The magistrate is an administrator. He has no power of discretion. He cannot, quote, judge anything, okay, unless you give him permission to. So the tribunal is independent of the magistrate. The one who does the judging is independent of the guy who's conducting the proceedings. Now, what is a magistrate? Since we know that the tribunal is independent, what is a magistrate? Well, we look down here. Magistrate, an official entrusted with the administration of the laws. Okay? Not the management, not the creation, just administration. No thinking aloud on the part of the judge. That's what administrators do. They follow the rules. They don't make up the rules. Okay? And as the sovereign of the court, you're the rule maker, and if you wish to suspend a rule, you can. Okay? So, a magistrate is a person clothed with power as a public civil officer. That's a magistrate. And we're saying here that in a court of record, the tribunal is independent of a magistrate. The tribunal is independent of a public civil officer. Okay? The judge is a public civil officer. He's a magistrate. How do I know that? Well, obviously I've concluded it from these descriptions, but you don't really have to be smart enough to conclude it. All you have to do is go down to California Penal Code, Section 808, persons designated as magistrates. The following persons are magistrates: the judge of the Supreme Court, the judges of the Courts of Appeal, the judges of the Superior Courts, the judges of the Municipal Courts, and the judges of the Justice Courts. They're all magistrates.
Judges of the judges.
All of them are magistrates. Okay? Are you satisfied that judges are magistrates? Well, now, the tribunal is the one who does the judging. And he's independent of the magistrates. Right here. Number 5.
So when you separate the tribunal and the magistrate, which one comes first, the denominator or the numerator? When you put a slice in
It's not who comes first, it's what the job description is. Okay?
The tribunal comes first.
The magistrate administers, the tribunal decides.
Right.
Okay? So, when you are the sovereign of the court, I mean, you have your kingdom. Now, if you want to grant power to the judge to make a decision for you, you can. And that's what happens. You go to court, and right away, what do? They bring in statutes, codes, right? I mean, you have your attorney write up the papers. He says code such and such says such and such, blah, 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 right? Well, right there, you're not in a court of record for that reason alone, because he brought in the statutes. All right? And then you go to court and the judge makes a decision. Boom, right there you know you're not in a court of record if the judge is making a decision. Of course, if you're in a court of record, and if you understand that, and if you're watching out for your rights, when he makes a decision, what do? Object, right. You say, I object. Why do you object? Now remember, you're the plaintiff when you do all this. This doesn't work if you're the defendant. Very important. Notice that. This only works if you're a plaintiff. All this stuff I'm telling you is only the prerogative of the plaintiff, the sovereign plaintiff. It is never the prerogative of the defendant. This does not work if you're a defendant. You do not own the court if you're a defendant. You're a subject of the court. So you must be the plaintiff if you're going to do any of this stuff. That's not such a tough thing to be, Because if you are the defendant, they started the trouble, I assume. Okay, they're coming after you. So you do a counterclaim, now you become the plaintiff, they become the defendant, and the issue that you raise is their jurisdiction. Do they have jurisdiction or not? And everything must stop until they prove their jurisdiction. No jurisdiction, what business do they have of proceeding? And how do we know whether they have jurisdiction until they prove it? Okay, so the proceeding, now that doesn't mean they do stop. I mean, you have to sometimes really get tough with these people. But they'll try to proceed anyway because they're always testing your knowledge. Right? They don't give up easily.
Oh, they don't?
No, they don't. If anybody knows it, she does. So, yeah, they don't give up easily. But you have to know to object. You've got to make the record. By the way, does anybody here know what the record is? What is a record? That's all right. That's all right. You don't have to answer it. I'll tell you. Okay? There's a lot of confusion about a record. The docket sheet that you see when you go down to the court is not the record. The docket sheet contains in it the record, but the whole docket sheet is not the record. What the record is a chronology of only two things. What was proposed to the court and what the decision was that was made. That's it. That is the record. All the other detailed transcripts, whatever it is, that is not the record.
What's the second one?
The decision made. The first thing is what was proposed to the court, like a motion, for example. And the second thing is what was the decision made. That is the record and nothing else.
They're in the back now.
The other stuff is supplemental, supportive, but the record is, what are you asking of the court? And did the court grant it or not? That's it. Okay? So, when the court keeps a record of the proceedings, that's all it's doing. Now, I'm sure everyone here is familiar with the word patient. You know, a doctor's patient. Now, does an auto mechanic have patients? No. He has customers, right? Does a lawyer have patients? No. He has clients. Okay? Only a doctor has patients. The doctors own the word patient. Okay? That is specifically associated with their profession. The word client is in this, just like the word patient is owned by doctors, the word client is owned by attorneys. A client is somebody with whom you have an attorney-client relationship, okay? And you can make decisions for him. Okay, you have control of his life. Power of attorney, that's exactly right. And so a licensed attorney has a higher level of attorney relationship than a normal power of attorney would have. Okay, because he can actually follow through in court, in the existing courts. So the attorneys own the word client. It is not proper to say, for example, an accountant does not have clients. They say it all the time, but that's an abuse of the word. The original proper legal meaning of the word client is as it's used in relation to an attorney. Now, the word record is owned by a court of record. Equity courts do not keep records. Even though everything looks the same, they are not properly called records. Okay? That's why they call them docket sheets. Okay? They're called docket sheets. They're dockets because they're not records. Or what do they call it? There's another name I've been coming across now.
Transcript.
Not transcript, but I think it's something about actions. I forget anyway, but anyway, they have actions, listings of actions, okay? And because they're not records. Only a court of record keeps records. The word record is properly only used when talking about the decisions and proposals that are made in a court of record. That's it. That's what a real record is.
Equity courts do not keep records.
That's correct. They may keep notes. They have a list of actions that were taken, but those are not properly called records. Now, all right. So the court of record is the one court. Now, if you look at the Constitution, let's go back to the Constitution, specifically Article 3.
I know, but
Wrong tie.
It's not paying.
And the thing that I want you to notice is that when you're up close anyway, the stripes go this way. The stripes do not go the other way. Okay, that's not an accident. I select this tie based on the stripes. You want to do a close-up? Okay.
then you're telling me you're the passenger, not the driver.
I should have perhaps worn a more obvious tie, but anyway, the stripes go like you're reaching for your sword. The sword was worn on the left side, and you reach across, you pull it out, you're ready to do battle. Okay? So the sovereigns, when you look at the no parking signs, you know you have the circle with the stripe? The stripe goes the same way. That's an order from the sovereign. Okay? That stripe is sovereign. Now if you go the other way, that would be from a subject. Okay? So that
from right to the left.
Yeah, from the upper right shoulder to the lower left hip.
Yeah, the
And
right
you'll
side
see when at public affairs and these medal happy public officials, and they have. All right. I mean, you have to take time out. You remember right at the beginning, I said sometimes you have to have a little sense of humor and levity. Okay. You can't. The court can be fun sometimes, and of course, they acknowledge that in court, they acknowledge that they have to take a break once in a while because that's a long-standing tradition to have a jester in the court. That's his job.
Have you ever worn that hat in court?
No? I probably ought to. Sometimes. Okay? Well, let's see. What else have we got here?
I want to see the powdered wig.
Of course you do.
Hey, he's got it.
Of course.
You wearing that, you must be legal.
Okay.
Court.
There you are. Okay. So the magistrate. Now, have any of you ever wondered why the wigs are always white? You ever wondered?
They run out of black.
No, they're always white.
They're all because it's
Why is there a tradition of white wigs?
let's see.
That's fur. Grab it out of the hat.
Nope.
They're all,
Nope.
they're always old.
White is light.
There was a period in time when the nobility had a lot of power struggles. Of course, there's always power struggles. I mean, that's guaranteed. But the power struggles got a little serious, and the customary way of settling power struggles was to incorporate arsenic. You know, you incorporate arsenic.
Poison.
Put a little arsenic in the food.
Poison.
What?
That usually settled an argument about power. Okay? Whoever ate it first lost. So arsenic was very common. Right? And that is how they settled. And it was brother against sister, father against son. I mean, there was no loyalty. You read the history. I've got a little book. I should have brought it in, I guess, but I have a little book on the history of Europe. And it's just a little book with maybe 100 pages, but every single page has at least 3 or 4 descriptions of somebody killing somebody in order to get in charge. Okay? I mean, this is how they did it. No loyalty among each other. They had nothing to do. They didn't work. So they would kill each other in order. Well, and arsenic was the favorite method. Well, somebody discovered that if you eat a little bit of arsenic each day, you could build up your immunity, and you could take quite a hit with no effect. But the side effect was that your hair turned white. So all the nobility had white hair. And so it was very easy to tell the nobility, a nobleman, from a commoner. Commoner had colored hair. Nobility had white hair. Of course, that was why they ate arsenic. Okay? Well, when arsenic lost its favoritism and no longer became popular, the tradition continued. And so when you have high court proceedings or very formal proceedings, they put on the white wigs. And that's why, because of the nobility. Oh, yeah. Well, they're I mean, look at the glorification of police now. When one of them dies, it's like a religious event. And people seem to gravitate to that sort of thing. They like glorifying. Let's see. All right. Superior court versus inferior court. You're going to love this. A superior court is a court of record. An inferior court is a court that's not a court of record. Okay?
Superior court is a court of record.
Right. Or the other way around. A court of record is a superior court. That's spelled with a small s. Now, just to keep you confused, at least here in California, they named the courts Superior Court, but that's just the name. Okay? Don't confuse the name with the function. So, the Superior Court, capitalized, usually is an inferior court. How do you know? It's not a court of record. It's not proceeding according to the common law. The judge is making a decision. The tribunal is not independent of the magistrate. Those are the two big ones right there. Okay? So anytime you walk into a courtroom, you see that judge making a decision. I don't care if they call it the superior court. It's an inferior court. That's what I would do.
You have to object to the proceedings.
Sure.
Counterclaim.
Well, yeah, if you carry it out to the full formal extent, you would counterclaim them, but in a superior court, a real superior court. Okay? Now,
Would that be an Article 3 court?
no, Article 3 court is a court that's under the Constitution of the United States. That Article 3 refers to the Article 3 of the United States Constitution. No, this is a court of record. Take it for what it is on its surface, on its face. Okay? Don't try to make more out of it than what it is. So, a court of record has its criteria. I gave you the criteria, and that's backed up by case law. I mean, there's been cases on that where that was challenged, and the court said, no, this is what a court of record is. So, but let's look at superior court versus inferior court. Okay. Now, in Ex parte Kearney, 55 Cal 212, and in Smith versus Andrews in 6 Cal 652, the court said, inferior courts are those whose jurisdiction is limited and special and whose proceedings are not according to the course of the common law. It's pretty clear to me. I don't know. What do you think? Okay? Their jurisdiction is limited. Let me show you an example of what we mean by limited. Can a criminal court judge a civil matter?
No.
No. Can a civil court judge a criminal matter? No. Okay? These are limited jurisdiction courts. So therefore, they're inferior courts. When you go to court and you try to make an argument, and the judge shuts you down because he says that's not related, Okay? What is he doing? He's saying we're staying within the limitations of this court. See, like the guy, we've all heard about the case, I'm sure, where the burglar came in through the roof and he fell.
Yeah.
And he got trapped in the garage, and therefore he sued and won for damages because he couldn't get out of the garage. Okay? Now, when you take the whole big picture, into account, that doesn't make sense. Now, I didn't see this case, but I can imagine how it went. You know, the burglar is suing the homeowner. The homeowner is saying, "But you broke in," and the judge is saying that has nothing to do with the case. You cannot trap a person in a container. Well, I'm just saying that the court had limited jurisdiction. The judge could not listen to anything else. He could only listen to the immediate things relating to this. Was he trapped or not trapped? Okay? Doesn't matter how he got there. Now, a court that has unlimited jurisdiction, which is a superior court, it can take these factors into account. Okay? It can take everything into account. It can take into whether the sun was up or down into account. Okay? So that's one of the big differences between a superior court and an inferior court. Now, criminal courts proceed according to statutory law. Jurisdiction and procedure is defined by statute. Likewise, civil courts and admiralty courts proceed according to statutory law. Any court proceeding according to statutory law is not a court of record. Court of record only proceeds according to common law. It is an inferior court. Now, the only inherent difference ordinarily recognized between superior and inferior courts is that there is a presumption in favor of the validity of the judgments of the superior court and no presumption in favor of the validity of the inferior court. Okay? Superior court makes a decision. We presume, unless there's some extraordinary reason otherwise, we presume it's a correct decision. If it's an inferior court, we don't make that presumption. We don't presume it's bad either. It just doesn't carry any automatic validity with it. Why? Because it didn't take all the factors into account. It only operated within its limited perception, its limited scope. Okay? Going on, it says, a superior court may be shown not to have had power to render a particular judgment by reference to its record. So you look at the record, and you can see whether or not it had jurisdiction. Okay? If it had no jurisdiction, then its judgment is no good. But if it had jurisdiction, it has a good judgment. Okay? Note that in California, superior court is the name of a particular court. Okay? So when it's capitalized. When a court acts by virtue of a special statute conferring jurisdiction in a certain class of cases, what are we talking about? We're talking about criminal courts, civil courts, right? Those are classes of cases. Okay? When a court acts by virtue of a special statute conferring jurisdiction in a certain class of cases, it is a court of inferior or limited jurisdiction for the time being, no matter what its ordinary status may be. Okay? The decisions of a superior court can only be challenged in a court of appeal. Okay, but the decisions of an inferior court are subject to collateral attack. In other words, in a superior court, one may sue an inferior court directly rather than resort to appeal to an appellate court. So you go through a case. They wouldn't let you put all the evidence in because it wasn't relevant, according to the judge. So after it's all over and the smoke blows away, you now file a suit and you name the court as a defendant. But you're not suing for money, you're suing for decision. Okay? The original defendants, they are the ones at risk. But, I mean, the original plaintiff who came against you, he's the one that's at risk for money. But you sue that court because your claim is the court was an inferior court, therefore couldn't make a good decision, didn't make a good decision. And we have to get all the facts in, all of the considerations, and that's why we're reopening the case in a real superior court.
So we're not in a court of record.
You're in a court of record the second time.
The second time.
Yeah. Second time you open it up in a court of record. You open up. Remember, a court of record is a superior court. Also, a superior court is a court of record. Works both directions. Okay? You're proceeding according to the common law. The tribunal is independent of the magistrate. So, any case you have, you can reopen.
No statute of limitations.
No statute of limitations, because there's no statutes in common law.
Is this different than a counterclaim?
No, a counterclaim is when somebody makes a claim against you.
Or cross-complaint?
Well, a cross-complaint, that doesn't count either.
Okay.
But a counterclaim is when somebody has a claim against you, and then you come back and make a claim against them. But in order to make your counterclaim really stick as a counterclaim, the first thing you have to do is challenge their jurisdiction. If they do not have jurisdiction, then all of the consequential injuries that you suffered now become collectible items. Okay? So now, the decisions of a superior court may only be challenged in a court of appeal. But that little statement only applies to state courts. It does not apply to your court of record. Okay? Let's see. Let's go.
Can you repeat that sentence again? I didn't quite catch it. The last sentence.
Well, now I'm in trouble.
No, it applies to them, but
It applies. The ability to appeal a decision only applies to state courts. It does not apply to your private court. Okay? Your court of record, where you're the sovereign of the court, well, it's King's Bench, basically. In other words, you're the king. You're there. So there is no appeal from the king. All right? So there is appeal from a state court because the king's not there. The judge is sitting there. If they're operating according to the common law, I'm not sure how they ever work that out. But I've never seen a court of record, frankly. They're all equity courts. In the English language, if the gender is unknown, then we use the masculine gender.
That's okay.
That's a rule. So when somebody uses a masculine gender, you do not know if the gender is male or female. See? A lot of people object to it because they don't understand the neutrality of that. So, anyhow, now you're going to love this next item. Okay. This last paragraph, I really ought to put this up front. Maybe I'll get around and revise this thing, the website. But it's the last paragraph. But listen to this. The Supreme Court in Schneckloth versus Bustamante, 412 U.S. 218, on page 255 in 1973. That case in 1973 cited a very old case called Ex parte Watkins, 3 Peters at 202 and 203. And what they said was this, here it is. No statutory or constitutional court, whether it be an appellate or Supreme Court, can second-guess the judgment of a court of record. Quote, the judgment of a court of record whose jurisdiction is final is as conclusive on all the world as the judgment of this court would be, this court being the Supreme Court. It is as conclusive on this court as it is on other courts. It puts an end to inquiry concerning the fact by deciding it. So when you have a court of record and you come to that final judgment, that's it, kiddo. Not appealable. Now, that doesn't mean you can't go at it again. Remember, I said earlier that you can have a new trial on a case. But what's the probability of winning? You know? However the jury decided last time, it's going to decide the same thing this time. You know,
So it could be a different jury.
Different jury. I mean, if you really had a jury that went awry, yeah, it might be worth a shot. But again, third trial only happens 2-3 times in a century. You know, it doesn't happen often at all. And so the system works. You know, but it's a new jury considering new things. There have to be new things pretty much, unless, like I said, you got a really sick jury, which is not likely. Anyway, the court of record, the decision of the court of record is not appealable. Any decision comes out of your court of record is not appealable. Your court is King's Bench. By the way, the word bench means court. Okay? So, it's King's Bench. You, whatever the king decides, you can't go above the sovereign. Okay? So, if whoever you're suing, if they don't ask for a jury of sovereigns, of peers, well then, ain't gonna make it. You know? You had a question.
Yeah, Bill. California Constitution says that a court of record, or that says that all three levels of court, Superior Court, Appellate Court, and Supreme Court, are courts of record.
Right.
So why did they do that if a court of record is not appealable?
Well, state courts, well, that is an anomaly. But remember this. The Superior Court can be an inferior court. We need a microphone here. The Superior Court may be an inferior court, and its decisions are appealable to the Appellate Court, which is a court of record, which can take everything into account. On the other hand, if the Appellate Court acts like an inferior court, its decision can be appealed to the court of record called the Superior Court. Let's see. Now, you all know, I'm going to bring out some important things in the review here. Number one, what are the two significant points about sovereignty that I've repeated before?
What's the question? Two?
What are the two significant things about sovereignty? What is characteristic of a sovereign?
No accountability to a higher level.
Right, that's one.
The decree of the sovereign is...
The decree of the sovereign makes law. Right. Very important. When you sue somebody, you make your decree of what the law is that you're saying got violated. The laws that you're claiming that they broke. They have an obligation to you of some kind. It could be an obligation to pay you money, or it could be an obligation to not punch you in the nose. But whatever the obligation is, an obligation to do or an obligation to not do, whatever that obligation is, you decree what the law is. So that's one point, that you have a court of record, or not a court of record, I meant to say sovereignty has these two features. There's other features too, but those are the key ones. Okay, no accountability to higher authority, and the decree of the sovereign makes law. Sovereignty is an important aspect of what we do here. You've got to have your sovereignty. Now, in order to make it work, you've got to be the plaintiff. So, I assume that you all know how to do a lawsuit. Now, this session we're having today is not a session on procedure. This is a session on concepts. I'm giving you the concepts with which to do procedure. We talk a little bit about procedure, but the emphasis is on concepts. Now, there is a company called, or a website a website called jurisdictionary.com. Juris, as in Sam, dictionary. All one word, jurisdictionary.com. And they sell a course, I think it's for $219, a 2-day course, and it's written by an attorney. It all has to do with procedure. Yeah, he goes into procedures, he talks about motions, he talks about evidence, talks about all kinds of stuff. Basically, he gives a rounded picture. He says it's a 2-day course. I suspect it takes longer to study it. But nevertheless, he's gone to the trouble to give you the generally acceptable court procedures that apply to all courts. So if you take that, procedure-wise, and add to it the concepts that we have here, you've got a real powerful combination. I haven't focused on jurisdiction. I haven't focused on procedure because he has. No point in reinventing the wheel.
Yeah.
And it's very reasonably priced. I want you to lock down in your mind
There you go.
those two things about sovereignty. This is extremely important that you always keep this in mind, that you're not accountable to higher authority and your decree makes law. Also, I want you to remember what a republic is. You're in your sovereign capacity. Now, if you're sovereign, you do what sovereigns do. You have your own court system. You have your own laws. You can do all that stuff. The thing that keeps you from getting too extravagant is the fact that if you do decide to enforce your laws against someone, they can always call a jury who can sit in judgment of your laws. You don't remember that. What is the number one definition of a court?
Stage.
It's a stage upon which you put a show. So if you're going to go in and buck the traditions and buck the customary way of doing things, all that does is generate trouble for you. Because, you know, there was this gentleman in Germany, his name was Goethe. He was a philosopher. And he said that there's nothing so fearful as ignorance in action. Okay? As ignorance in action. There is nothing so fearful as ignorance in action.
Okay.
And so you go in there with your superior knowledge, supposedly superior, and these people don't know what you do, and they just might go into action. And you might find yourself behind bars, all because you knew something they didn't. And you knew that it didn't matter whether or not you wore a hat. But they told you to take the hat off, and you didn't, so you went to jail. Okay?
Well, that's the only.
I suggest that you don't challenge the people around you. Remember this. There's a very important rule. In the land of the insane, the sane man will be adjudged insane.
Yeah.
Okay?
That's true.
So understand who's around you, and you know, you got to put a proper show on, and you got to take into account that you're not actually free, even though you think you are, because you can get these kickbacks, or blowbacks, I think is the new term. Well, basically, you had to put up with either their lack of knowledge or their choice to ignore what they knew.
Oh, yeah, they did.
That happens. Well, anyhow, so keep in mind, as I said before, what sovereignty is. Keep in mind that the number one rule about courts is that it's a show. You want to put on a good show. And even though you're right, if it's a bad show, then don't do it. Don't claim it unless it's really, really critical to what you're doing. Keep in mind what a court of record is, and that it's proceeding according to the common law, and don't allow the judge to make any decisions. Okay? Now, if you're the sovereign of the court, you're the plaintiff. If the judge makes a decision, all you do is you object. We have on this disc, what do you do when you are in front of a judge? Okay? This is very important. See, when you have your paper, when you're in your court process and you've done your counterclaim, if you're in front of a judge, the reason you're there is because somebody, either you or the other side, is asking the court to do something. That's called a motion. Okay? And so the judge is going to try and make a decision. If it's your court, and you have a court of record, he cannot make a decision. He's prohibited. But that doesn't mean he won't do it. And so when you're in front of that judge, you want to be able to keep things under control. And under control in the sense that even if he doesn't do the right thing, you're not lost. Okay? So you have to be the plaintiff, as I said before. Now here's what happens. I'll just read off this article. It's short and sweet. When you are a plaintiff and one of the people of the United States or a state in a court of record, the judge has no power to make a decision unless you grant it to him. The tribunal, which is either you or a jury, is independent of the magistrate, and all judges in California are magistrates. When in court, there is no need to argue your case. All of your arguments should have been made in the preceding paperwork. The only reason for a court hearing is to give the court an opportunity to ask questions of the litigants to clarify any points. Anything you say in court is considered an ovation to your papers on file. Your verbal actions override your previous papers. That's why you don't talk in court. Now, get this. Somebody makes a motion. That's whatever it is that he wants. Says, I want this from the court. The other person answers the motion from his side. And he introduces his own pecados, whatever. And then you have a third chance to come back and say whatever it is, but your answer, your reply to his answer is narrowed down to the issues that were raised in his paper, okay? That's your typical 3-paper set. Everything you have to say should be in those papers. Basically, you spoke on paper and the other side spoke on paper. That's your speaking. The only reason for a court hearing is so that the court can ask you questions. That's it. A court doesn't have to have a hearing at all. And in fact, if you go down to Florida, down there in those courts, you put your motions in and you get your rulings back. You never have a hearing. Normally you don't have a hearing. Why? Because those guys down there, apparently they feel they understand your paperwork. There's no need to call you in. If they do have questions, they'll set a hearing date, notify you, and you come in, and then you talk. But the only purpose of a hearing is to give the court a chance to speak or ask questions to clarify points. That's it. Your argument is through when you put that paper in. So knowing that, here's our procedure. Just as I said, when in court, there's no need to argue your case. All of your arguments should have been made in the preceding paperwork. The only reason for a court hearing is to give the court an opportunity to ask questions of the litigants to clarify any points. Now here's some suggestions on court procedure. First of all, don't verbally discuss anything in court. Nothing. The judges and attorneys in court are word masters. They are much more practiced at word interpretation and manipulation than you are. Anything you say will be held against you and will provide opportunities to nullify your paperwork. The best thing is not to discuss anything. When the judge asks you anything about your papers or points, you should only say, I have nothing to say. It's all in my filed papers, Your Honor. Okay? That's it. Do not discuss it. That forces the judge to consider your papers rather than what you may say in the hearing. You open your mouth, you're dead. Okay? Because now he interprets. You say it's raining outside, and he interprets that to mean there was no rain at all. You know? You have no control over his interpretations. Therefore, don't give him ammunition. All right? He wants to know what you have to say. It's all in the paperwork, Your Honor. I have nothing to say. Second thing, object to anything of which you do not approve that occurs in the courtroom. Okay? I object to the hearing. Of course, if you made the motion, don't object to the hearing, okay? But if the other side made the motion, object to the whole thing. Whatever it is, whatever they say, if you don't like it, object to it. Certainly don't allow any decisions on the part of the judge without objecting. Okay? He makes a decision, you object. All right? So here's a script. Typical courtroom scenario. Something happens in the courtroom. Whatever it is. You say, I object. The judge says, why do you object? You say, it's not my wish. The judge says, if that's the best you can do, you're overruled. And you say, well, for the record, I do object. And then he says, your objection is noted. Okay? And he might even say, you're overruled. Well, what you did is you registered your objection. That keeps it open. Yes?
What about I take exception to your ruling?
Well, if you want to be an entrepreneur and create new procedures, that's up to you. But I suggest you follow the standard procedure, which is to say, I object. You know, otherwise you're taking a chance.
No, that's the second one. You object, he says overruled, then you can say I take exception to that.
Well, if you want to, you can. I mean, but once you've objected, that's it. I mean, he made the ruling. That doesn't mean that he's authorized.
It's on record.
It's on record. You object. Okay?
So can you find you in contempt if you keep objecting to his rulings?
Well, it doesn't normally get that way unless you've generated a lot of hate in the courtroom. I mean, I keep these things friendly. You know, I mean, if the judge finds you in contempt because you object, that tells me that something's wrong here in how you handle things. Because objecting is such a standard procedure. Nobody's going to find you in contempt. All you're telling me that he's using it as an excuse to carry out another agenda. All right? So I suggest that you get to that stage, something's wrong. You should have been alerted to yourself long before that you're not handling things right. Just to object, you know, and you don't have to be loud. You don't have to be obnoxious. You say it with a smile. You know, I object, Your Honor.
How do we get the report for that to find out if we objected? I mean, do we have to pay for the...
No, don't you know when you object?
Well, if it's not recorded now. Oh.
It's recorded in your memory.
Oh.
I mean, you know, you just move forward on these things. You make your claims. In your paperwork, when you file paperwork later on, you state in your paperwork that you had objected. You know, whatever your follow-up paperwork would be. You know, that becomes part of the whole history, you know, of the court proceeding. Yeah, you know, I understand that they don't always put things in the record that they should have.
Take notes.
Huh?
Take notes.
Yeah, they don't always make notes. You make notes, but they don't. You know, so anyway, but you see that little proceeding, just as I showed it there, that's really all that's necessary. My hearings seldom last more than 5 minutes. Okay? Because I don't stand there and argue. I just say object and I let him roll on. What takes me a lot of time is the full day or 2 days it takes me to write the paper to reverse his decision. That takes time. But, you know, the actual proceeding is extremely short normally. Now, I have no control over the other side, but usually the other side doesn't have much to say either. But you can encourage them to say more if you want and run your transcription expenses up. But if you just keep it simple and say, I object. Okay? All right, so that's all that is necessary. You then move on to the next item of business. All right? The judge is going to do whatever he chooses. You have not the power to stop him at that time, just as you have no power to stop a robber from robbing you. At this point, your only goal is to object for the record. Later, after you leave the courtroom, you type and file the court order to vacate or correct the judge's decision. But remember, this can only be done if you are the plaintiff, one of the people of the jurisdiction, in a court of record, and have not given anyone, including the judge, any permission to do anything in your case. Okay, you've got to have this thing locked down. And so if you're in a court of record, it's an absolute, no exceptions. The judge cannot make any decisions whatsoever. Okay, you are the decider. And then finally, point number 3 in a proceeding, if you are, let's say, incarcerated, and they bring you out before a judge, then this next paragraph applies. If you are a defendant who is the petitioner in a habeas corpus or a plaintiff in a counterclaim, you should repeat to the other court your demand to be released. You are challenging jurisdiction. Because they asserted jurisdiction, you should from time to time remind them of your demand to be immediately released from their custody. They probably won't release you, but again, you're building the history of the case, and this all works against them in the long run.
Do you become an injured party if they continue custody?
Yes. Yes, you become eventually an injured party because they held you without jurisdiction, assuming that's the point, assuming that you arrive at the point where you've determined that they don't have jurisdiction. This is the copy of the indictment against Sherry Jackson. Okay. Now, well, actually, it's not an indictment. It's an information. Everybody know the difference between an information and an indictment?
No.
Okay. An indictment is when the district attorney goes to the grand jury, and the grand jury looks it over, and if they think that the person should be prosecuted, they then indict the person.
Bring charges against them.
Yeah, basically. Right, bring charges in plain English. But they call it an indictment. If the prosecutor does not go to the grand jury, the alternative procedure is that he puts together what's called an information. It's basically an affidavit. In other words, a statement under oath, under penalty of perjury. And he takes that to a judge, actually to a magistrate, okay? And the magistrate kind of functions like a grand jury, and he decides whether or not the prosecutor can proceed. And so that's what an information is. So in this case, they prosecuted her based on information rather than based on grand jury indictment. Now, remember this important concept. The sovereign establishes the court, the plaintiff. If you're the plaintiff, you determine what form you want to go in. You determine what the laws are and so forth that you're going to prosecute under, whether it's civil or whatever. The IRS is assuming the posture of a sovereign. They are opening up their court and they're bringing their charges. Now, after everything I've told you, you know that they cannot be sovereign relative to the people. They are sovereign relative to the citizens. Right? Is that clear? The people own the government and the government owns the citizens. So the IRS is taking the position when they file their claims, they're taking the position that they are sovereign and they're treating the defendant as if he were a citizen. They don't stop to ask, are you one of the people or one of the citizens? They just roll on forward and assume you're a citizen. So look what it says in this indictment, or I mean in this information. This is basically, this first page is a notice, or it's a summons. You are hereby summoned. So that's the first page. You go to the second page, and notice what it says. This is count 1. On or before April 16, 2001, in the Northern District of Georgia, the defendant, Sherry Peel Jackson, who is required by Title 26 United States Code and by regulations made under the authority thereof to make a federal income tax return for the calendar year 2000. Right there is the declaration of the law by the sovereign, the decree, right? Do you all see that? Who is the plaintiff in this case?
Sheriff.
The government.
The IRS. Sherry's the defendant. The IRS is the plaintiff. Who's the sovereign of the court? The IRS, right. That's the position that they've adopted. You've learned your lesson well. Okay? So now, the sovereign has spoken. The sovereign says, you're required to file. That is the decree of the law. See, it looks like, to the person who's not made aware of this, it looks like, okay, they made their statement as required, okay, and you're going to defend against it and so forth. No, this is the law, decreed by the sovereign. Okay? And having had and received gross income in excess of $12,950, the minimum filing requirement for calendar year. See, that's another declaration of law. That's the minimum filing requirement, specifically stating the items of her gross income and any deductions and credits, and he's calling it income. That's also a decree. He's saying what is. This is not, shall we investigate? This is what is. See, it's a very affirmative statement. And it goes on to say what her violation of that law was. She willfully failed to make such return at the time required by such law and such regulations. That is, on or before April 16th, in violation of Title 26, United States Code, Section 7203. So first they decree the law, and then they say that she violated that law, and that this is supported by another law that they're also decreeing. See, one of the things you got to really perceive here is that I can say that that black car is white. I can say that black car is white if I'm the plaintiff. And if the court says the black car is white, then it's white. Okay? That's the law. Now, a person looking at it and say, well, how did he ever come to a conclusion like that? Doesn't matter how he did. The point is, the court had a considered it, and came to this conclusion. Right or wrong, there it is. Now, some people, sometimes it gets so gross, you appeal it, and the appellate court will admit that there was a violation of that there was a violation of discretion on the part of the judge and so forth. But that's when it becomes politically infeasible. What are you saying? Is everybody in tune with me, what I'm saying here? The IRS is assuming the posture of sovereign, and then they are decreeing what the law is, and then they're saying, here's how the law got violated. Now, look at Sim Cannon's case. Sim Cannon was very, very similar. I don't have his paper here, but here's what they did. They went through the whole process, defense and all that sort of stuff. Got to the jury. The jury sent a note to the judge asking, did they have to go through all 700 pages of information to find the law, or could the judge provide them the law? The judge wrote a note back to the jury, and he said, I have already made a determination that the law requires him to file. The jury only has to determine whether or not he filed. So, and in the trial, Sim Cannon always admitted that he didn't file. So it was a slam dunk for the jury to decide. And the judge didn't lie. The indictment came in. The IRS, I'm sure, decreed the law just in the same style that you see for Sherry. And so then they came through and they prosecuted, right? They said he violated and they prosecuted. And this is where they ended up. So that's the law. It didn't exist until the moment of accusation, but the sovereign said so. And the judge knows this, but the judge is not going to fight the sovereign, right? It's not his job. So that's how it's done.
And Sherry did no counterclaim.
Correct. Now, look at count 2. Not much to look at, actually. Required by Title 26 United States Code. They don't even cite the code. He just says they're required. Well, it's true until proven otherwise. And then who has the discretion? And the way they worked it out, you know, she lost. But do you see the mechanics of it is the sovereign opens up his case, chooses his court, chooses his forum in the court, decrees the law, then says the law was violated, and then the jury, not understanding all of this, the jury thinks it's got to decide the facts. Did he or did he not, or did she or not do whatever they say is required? And of course they always say he didn't, because the defendant always admits that they didn't file. That's not the question in the defendant's mind. And then the defendant says, show me the law, right? Where's the law? But they're looking over at the codes. It's not there. Never was there. And the judge sits there and he sees the law, but he doesn't take sides. He remains. Does everybody genuinely see this, how it's working? Slam dunk. Yeah, that's why they're getting so many convictions.
Well, how did Tommy Cryer win?
Yes.
So, what should have happened in order to invoke common law at the time this...
Counterclaim. Sue back. I'm the sovereign and you're the agent. You are exceeding your authority. You bring back your own decreeing of law.
Is there a period of time you can do that?
Instantly.
At the very beginning.
Yes, instantly. Do not wait. Come right back. Punch back.
You don't know.
Well,
You found out after 30 days.
there's a maxim, okay? Legal maxim. The law does not protect he who slumbers on his right. And ignorance of the law is considered equal to slumbering. If you haven't taken the time to learn about the law, learn your rights, learn the system, and I'm not blaming you, I'm just saying, you know, because the educational system is all set up to encourage you to not know what your rights are, right? To not understand the system. And so we know where to put the blame for the training, but the fact is the courts operate as if you were sovereign, and because you're sovereign, you are fully responsible, and if you're ignorant, well, that's too bad. Seen one count, you've seen them all. Count 3. Required by Title 26 United States Code and by regulations made under the authority thereof to make a federal income tax return for the calendar year 2002. Count 4. Sherry, I believe, is appealing, and she's out until, no, I think she's been given a couple of months before sentencing. She really ought to go back on. I sent an email to her husband, and other people are telling me that they're going to send mail to him, but you know, it isn't going to work for her. You know why? Because she herself must be herself in this process, and she doesn't know. She's going to say the wrong things and slap herself right into jurisdiction again. Counterclaim.
Yeah, but what would you do? Specific.
I'd sue him. I'd put the counterclaim together and sue him. Serve him with the counterclaim. Look, a counterclaim is no different than an ordinary lawsuit. It has all the same things. The real difference is the name. Yeah, it's counterclaim instead of claim. It changed the title, okay? And they are now counter defendants and you're counter plaintiff. But that's the important thing. You're the plaintiff. And then you establish your sovereignty in your paperwork. I'll show you that in a few minutes how you do that. But you establish your sovereignty, and now that you're in your sovereign capacity and it's your court and you decreed what the law is, and remember, they're servants. There is nothing in the Constitution, nor can there be anything in the statutes, because the statutes must conform to the Constitution. There is nothing there that authorizes them to take command of a sovereign. Anyhow, see, I'm really intent on this. I want you to really, truly, in your gut, see that they decreed the law, and that is the law at the moment of the case. Anytime you file a counterclaim, they have 30 days to answer. But when you file the counterclaim is based on jurisdiction. So nothing can happen until the issue of jurisdiction is resolved. When you challenge jurisdiction, everything must stop. Now that doesn't mean they stop. They'll try to push forward, okay? And then you have to go through enforcement procedures to stop them, like a motion to stop them of some kind, okay? Yeah, it's a motion to cease or whatever. Actually a motion for prohibition, okay? To prohibit them from proceeding. Or to stay, a stay motion. There you go, that's the word.
Okay.
Do you have to go to the court again, or they send you mail?
Of course you go through the court. Of course you file in the court. You can file by mail, but you know, you file in the court, sure. But that's the counterclaim. I want to focus on this. If there's any doubt about any aspect of this, what I'm telling you, raise it now. Because I'm going to assume you all got it when we get to the next step. Well, apparently there was a court action which resulted in some sort of estoppel order on the IRS. Now, she's saying, who's funding them and keeping them going? How come they keep going? Well, the answer is simple. Nobody's enforcing it. That's all. They chose to ignore it. They move on, and nobody enforces it. So there you are. What should happen is whoever got that order should then bring them in for contempt of court. And then the court can use its contempt powers then to put everybody in jail if necessary to get that order obeyed. But that's a separate issue. If nobody complains about an order being disobeyed, it's as good as obeyed as far as the court's concerned. You've got to bring things before the court. Remember this, when you want something from the court, you always do it with a motion. The first motion that you make is not called a motion. The first motion you make to a court has a special name. It's called a complaint. But it is a motion just like anything else, okay? Yeah, you make a request of the court and you provide all the supporting evidence, and then the other person gets a chance to answer, and then you get to reply to the answer, and then they get to reply to the reply, and it goes back and forth under common law. Under the present equity system, there's only 3 papers. You make the initial paper, and then there's the answer, and then there's a reply to the answer. You're not allowed to bring up new issues in the reply to the answer. The purpose of the reply is to reply to the new issues brought up by them. See, they answer your accusations, but then they can bring up something. So then you have to have an opportunity to reply to that, and then that's where they cut off normally. They keep saying, show me the law. There it is. That is the law, the decree of the sovereign. And they are sovereign until somebody comes along and says, no, you're not. But you have to do it the right way, and defending is not good enough, because defending, see, the plaintiff is the sovereign, the defendant is the subject of the sovereign. So you got to flip that relationship. And you do it with a counterclaim. The counterclaim comes back and says, hey, wait a minute, I'm the sovereign here, and you guys are doing this wrong. And when you challenge jurisdiction, that's the point. When you're challenging jurisdiction, everything stops, because they have to prove to your court that they do have jurisdiction.
Could that be rephrased to say that they're giving a presentment, and unless you counter that presentment, it stands?
Well, yeah, you can put it in commercial terms if you want. I mean, it's pretty much the world operates by the same formula regardless of how you label it. You know, it always starts off with somebody presenting something, accusation or request or whatever, and then the other person comes back and says yay or nay, and then the other one comes back another time. You know, that's the pattern of life.
Okay, and in this case they're giving a presentment, and when you counter it in court without doing a counterclaim, they just overrule you and go on.
Right, yeah, because see, you're not saying that they injured you, you're saying I haven't injured him. Well, so the question centers around the complainer. So you've got to come back, and you see, normally the defendant, by custom of what we say, okay, what we say isn't necessarily what we do, but by custom of what we say, the defendant is innocent until proven guilty. But that's not how it works, really.
No.
You're guilty until proven innocent.
You're condemned.
Sure. And the proof of that is if you don't answer, you default and you are guilty. See, that's how it works. Now, that doesn't work that way in criminal proceedings. See, criminal proceedings, if you don't answer, they have to find you, catch you, and bring you in before they can default you. And it's not a default. They have to go through the paces.
Right.
So they, in the civil type thing, or in the common law situation, the accusation is made, and then there's the default or the presumption, and then the only way you can get around this is you have to say, wait a minute, where is your jurisdiction? In all proceeding, normally, if you make an accusation, you have to also provide the evidence. When you challenge jurisdiction, that is the one exception to the rule. When you challenge jurisdiction, all you have to say is, what jurisdiction? And the burden is on the defendant to prove that he had jurisdiction in his case. That's the one case where the burden of proof falls on the accuser. On the defendant. Actually, counter-defendant. Okay? So he cannot proceed until he proves jurisdiction. Now, if you don't question jurisdiction, he automatically has. There's another rule. If you fail to object, it means you agree. That's universal among all courts. You have to object. And you object with a counterclaim, or you object by other methods. But if you don't do any objection, that means you agree. So here we are, Sherry Jackson again. They made the accusation. She never objected to the law. What she said, I'm guessing, is, where is the law? Show me the law. And they did, only she didn't know it. And her attorney didn't know it. I'm sure he didn't know it. I'm sure. These guys are not that bright, okay? I mean, they're intelligent, yes, but they're not that well educated. I mean, this is a whole completely different view based on sovereignty and such. They don't get that kind of training in law school. So he looks at it, oh, all right, this is the accusation, so we do the standard defense. And then they get convicted and everybody wonders why. Look at Irwin Schiff, okay? Irwin Schiff, same deal. He got, I guess, indicted. In his case, I think he got indicted. But nevertheless, now, I talked to Irwin Schiff, and I could just tell, just by the way he reacted, he wasn't really seeing it, what I was saying to him. Of course, I only had a few seconds really to talk to him because somebody else had convinced him to call me, okay? And so we eventually got together in a discussion, and we talked for, I guess, a half hour, something like that, a good length of time. It was about a year before he got convicted. I don't know when he got convicted. October 2006 was the conviction, so it must have been a couple years before that or something, or a year, I don't know. I'm not tracking it. But the point is that just before he went through all that, well, maybe a year before he actually got convicted, I tried to tell him this stuff, and I tried to bring it to his attention about 26 U.S.C. 7806, which says the rest is not law. He didn't buy any of it. And then he just before he hung up, he said, well, I'll call you later. I'll get back to you on this. And I said, I don't think you will. But I could just tell by the way he's receiving it. I was just simply on Mars, you know. Somebody coming in and saying that you can dump the judge and that type of thing. It's just, but you can see here, I've got the cases that back up what I'm saying. Presumably you're looking at exactly what I'm looking at, and presumably you can come to the same conclusions I do based on those same things. But it was just too far out for him, and he stayed with the standard route of defending. But the problem is that the government was absolutely out to get him. And so that judge did everything within his power to stop the appropriate evidence from getting to the jury. Okay? And they are, yeah.
Did you look at the Larkin Rose case at all?
No, but you see, Larkin Rose doesn't answer my email. You know, I've written to him. Eventually I did get to him, and we did have some communication, but we went nowhere with it. See, Larkin Rose is a guru, okay? I mean, and my experience has been that everybody who truly, really in-depth knows their subject, and Larkin Rose does know his subject. I don't take that away from him. They can't switch to a different philosophy. See, it's not that they don't know or do know or don't know. It's a question of a system of thought. And this thing totally inverts the whole structure. Now, if somebody will listen to me several hours like you have, I can lead you through the path that leads to the conclusion. And then once you see it, well, at least I think it becomes obvious, you know. But you have to get down that path. Talking to somebody on the phone for 1 hour doesn't do it, see? And that's all I usually get with these guys. So there's not too much hope of them seeing this without somebody really spending some quality time with them and giving them an opportunity to challenge. And then, one more thing, they have to actually listen to the answer. And these people who are well versed in their subject area often are not good at listening. You know? Yeah, now look, I hope you guys pin me to the wall on this if I ever quit listening. Okay? Because I mean, I've seen the tendency in myself too. You know it so well. Somebody comes off the wall with something different, obviously they're wrong. Bad attitude, but it just human nature, you tend to gravitate toward that. But I ask them a key question. Sometimes I try to offset, and rarely does it work, but sometimes it does. I'll say, all right, you go to court and you lose a case. What do? Who made the decision? They say, well, the judge did. All right, so how do you handle that? Well, we appeal it. Okay. I say, that's not what I do. So they say, what do? I say, I issue an order vacating his decision. Can you do that? Well, right, they can't do that, they don't do that, and they don't believe that I did it. Okay? So, it's really tough to get through to people who already have basically, see, they've paid their dues. And I can understand somebody who's paid his dues to not exactly cotton to somebody who's just new in their minds, in this business. But I've been doing this now I've been at this since around 1983. Okay, but I didn't really get understanding until about 1990. That's when I started, and I didn't do it by myself. I had a tremendous amount of help from a lot of people, in discussions and points of view and so forth. So it was a long road to coming to where I came on this stuff. And then hopefully it's organized well enough so that you guys can now pick it up and at least do something with it. We've heard a lot about the fact that when somebody is taken into custody, that they become an asset of some kind, where people can somehow the bonding process and so forth. But our purpose here in the seminar is to show you what the law is and how to deal with it. Not right now, yeah. Good. Give me time. Yeah.
And neither is Linda Wall of Preferred Services, because she did his approach. She didn't. I don't know if she used a counterclaim or not. But again, she questioned jurisdiction,
Right.
jurisdiction. They dismissed.
It's easier. It's easier to do that dismissal with a counterclaim than it is, because you're putting their paychecks at risk.
And one thing too, Mr. Bill, doesn't mean if you have to go to a building in the courthouse to be in court. When you're riding your car and you're in the street and the cop pull you, you're right there in court with them.
Yeah, right from the get-go,
right there
you're in
from
court.
The get-go. They're acting as a judge the whole night, the whole shebang.
Anytime you have any interaction with these people, never forget that you're always in court, right from the beginning. The moment that cop opens his mouth and says anything that's against your interest, you're in his court. Okay? And yeah, so you right from the get-go, it's what's your authority. You know, you may still get arrested, but it's what's your authority. You can be nice about it. You can be non-challenging in the sense you say, I don't understand what your authority is. You know, you could be nice, but don't ever let that point get away.
I had one that worked. A cop pulled me over for cracked windshield and expired registration. First thing I asked him was, where was the emergency? Was there a life-threatening situation? He said, no. Why? I said, when you turn on your lights, they're only supposed to be legally used for life-threatening situations. You didn't violate the law, did you?
There you go. That's a cute one.
He said, well, tell you what, fix your windshield and do your registration. I go,
Very good. Yeah. Well, I think, I haven't dug into that issue myself, but my understanding is that they can only pull you over for probable cause, and probable cause means the committing of an arrestable offense.
And
Say,
not only
a real
that,
crime, not an infraction. Okay, what we're going to do then is we'll jump to the next step, which is the remedy. Well, in a word, it's a counterclaim, and you challenge the jurisdiction. What is your jurisdiction? Let me show you, I can show you a format on the counterclaim so you can see it. Now the thing is that different courts have different formats. If you're in California, or if you're in the well, maybe not, I won't say the Ninth Circuit, but at least in California, there's a very definite statewide format, which is controlled by the rules. But you'll find in other states they have other formats. So what I'm saying here, the format may be different, but the elements are the same. You still have to say who the plaintiff is, who the defendant is, but where you put those things where you type them on the page varies from one jurisdiction to a next. But let's see. Let's go back to I'm a strong believer in the concept that I am no more interested in a person case than he is. Saves me a lot of work. Not familiar with the case, no, but I'm sure it runs along the same lines. I mean, every person I've talked to, I mean, I know about Al Thompson. I know about Sim Cannon. There's another guy, Jerry something or other, who was out toward Redondo Beach somewhere in that area, and Irwin Schiff, you know, and all these guys, they defend. You can't defend in deals like this. I mean, it's a slam dunk pretty much to get you. Once in a while, one of them gets through the system, like, you know, that attorney, what's his name?
Cryer.
Yeah, Cryer. Tommy Cryer was I won't say he got lucky. I'm sure he did his research and he was very effective, but it was a fight right down to the end. With this approach, the fight pretty quickly comes to an end because suddenly you're issuing orders. You know, that's a lot nicer position to be in. Let's go to yeah.
Cryer had Beecroft, who is
yeah.
theory attorney.
Yeah. Well, I remember Beecraft. I have it on my website. I have a challenge to Larry Beecraft. When I started talking about sovereignty, I was fine with Beecraft until I brought up sovereignty. Sovereignty is what gets you out of their jurisdiction. See? He about blew a cork. I mean, he was yelling at me. He was calling me names. And then finally he stormed out of there and took Bill Benson in tow with him. Let's see if I can find it. First of all, I want you to show you how to structure the lawsuit itself. Let me explain something about the term lawsuit. Now, I've been talking about lawsuit all along, but I want to tell you right now that legally speaking, I'm using the wrong word. What it really is that you have actions at law and you have suits in equity, or equity suits. When you talk about a suit, that's equity. When you talk about an action at law, that's law. Then along around the beginning of the prior century, they came up with this great, fantastic idea. They said, let's put them together. There's only one form of action. You ever seen that? So they have law and equity combined. They're no longer wanting to distinguish it. The problem is they have to distinguish it because the Constitution has not changed.